as soon as I can get there. We are applying for a MyBlissy grant through the state, and what is one of the components is a support letter from principals. And MyBlissy is just a kind of behavior, PBIS, connected with some reading intervention. So we'll tell you more about that.
It's support for districts and schools to integrate literacy and PBIS into one system, which we have been trying to do and working towards that, but it's just, if we receive the grant, we will get more support from MyBlissy personnel to help us down that road.
Yep. So we're just asking all principals just to sign the letter that Mary so graciously crafted for us.
So if you don't like it, complain, Brian.
That's right. Go ahead. All right, Dan, we're all set. We'll have people come as they get here.
That sounds good.
Thank you.
My name is Dan Martin. I'm an attorney with the Thrun Law Firm, and I've been asked to present on Section 504 for you today. There is a presentation. A handout has been provided to you. If you need extra copies, just let me know. At the end, I'm going to be giving you a quiz, in part just to see if I'm delivering the material well enough that you can then use back in your building as well. Brian's indicated that they'll make it available online for teachers to take. The first slide is basically caveat. We attorneys like to protect our backside. So this is basically saying that this is educational in nature. I'm not giving you legal advice. If you actually want legal advice, call me or another attorney, and they're copyrighted materials. If you want to make copies, you need our permission, and I've already given the district permission. This slide is not in your presentation materials, but I put it up here because it's my kids, and I put it up here for a couple different reasons. First and foremost, because I love them. These pictures were taken a few years ago. My son, Aiden, is on the left. He's now a junior in high school. But he's in front of a quote that says, "There is no learning without first posing a question," without having to pose a question. If you have questions as we go, raise your hand, ask them, shout them out. I will respond to them as we go, typically. If there's a slide that's coming up, I'll probably let you know about that, but it makes it more interactive. It's something that's on your mind. I don't want you to forget about the question. It'll be helpful. The question should be picked up by the microphone as well, and typically I will repeat them to make sure that the listening audience can hear them. My daughter Sophie's currently in 8th grade. She doesn't look like an 8th grader here. She looks like a little kid because she was a little kid at that time. But she's in front of a quote that says, "I have a vested interest in the future because I plan on living there." I think people who go into education do so not for the money or the respect or the admiration of the state legislature, but because they care about kids. I personally think kids are not only our future, but our present. I want to thank you very much for doing what you do on a daily basis, because I know it's not easy. The first thing we're going to talk about are some of the basics of Section 504, which comes from the Rehabilitation Act. And essentially it says that schools cannot discriminate on account of people who have a handicap. And so this is the statute itself that specifically says anybody who's a qualified person with a disability cannot, for reason of that handicap, be excluded from the benefits of, participation in, or be discriminated against any program that receives federal funding. So this could potentially even apply to private schools that might receive some federal funding, for example, for a free or reduced lunch at a private school. Definitely applies in public school. Significantly, the thing to point out is that it prohibits discrimination on the basis of disability. It ensures that we have equal access for individuals with disabilities and those without disabilities to all of your school district's programs, activities, and services. This means if a student doesn't have a disability himself or herself, but has a parent who has a disability, you may need to provide accommodations in order to ensure that that parent can allow their student to access various programs. So that means if a parent needs a hearing interpreter, sign language interpreter, and they're coming to parent-teacher conferences, you have to provide that. Section 504 is a civil rights law, so it's enforced by the Office of Civil Rights through the Department of Justice. This diagram shows the student population, if you will, in sort of concentric circles. to help you try to understand a distinction, if you will, between 504 and special education under the Individuals with Disabilities in Education Act. So you look at the really big circle, and that's all the students within the school building. Some of those students might have impairments. I, for one, have an impairment. I look around, I see a couple other people in this room who have impairments, glasses. We have vision impairments. We need glasses in order to be able to see better. That doesn't mean we're eligible for a 504 plan. As you'll hear a little bit later, generally speaking, when you have something that can help you no longer have the disability because of like glasses, glasses is the only exception, if you will, that precludes you from not having a disability. Those of us who have the vision impairment, even though we have poor eyes that substantially limit a major life activity, the fact that we can have glasses or contact lenses excludes us from being a person with a disability. Students who might have a different physical or mental impairment that substantially limits a major life activity might be eligible under 504. Those are going to be students with disabilities. There's even a subset of children with disabilities who are eligible under the Individuals with Disabilities in Education Act because they have one of 13 listed disabilities under that federal law that says they're eligible and that they need special education supports and services in order to receive a free appropriate public education. So the students who are special ed are a subset of students with disabilities. Students with disabilities could be eligible either under IDEA if they meet that qualification, and if they don't, they may be eligible under 504. This is again another comparison between those two laws. 504 is a civil rights statute, whereas IDEA is an education statute. IDEA is saying we are going to educate students with disabilities and provide them a FAPE. 504 says you're not going to discriminate against students with disabilities and provide them a FAPE. FAPE is free appropriate public education. Under 504, we're not getting any specific funds in order to do this. Because we get other federal funds in other areas, we're required to comply with 504. But there's no funding specifically attached to it, in contrast to IDEA. And I will say under IDEA that the federal government does not fully fund your special education. Far, far from it. Under 504, we have a very broad definition of disability. As you've heard me mention, basically a physical or mental impairment that substantially limits one or more major life activities creates a disability. IDEA is more narrow. They've got 13 specific eligibility determinations and categories. Other than that, they're very similar between them. You have to do evaluations for both to ensure whether or not you're dealing with a student with a disability. Again, the qualification is going to be a little bit different because IDEA is more narrow. If the student qualifies under IDEA, they get an individualized education program. If they don't qualify under IDEA, but you find them to be a student with a disability, they can get a 504 plan, which is going to provide certain accommodations for them. The idea behind IDEA is that we are providing a meaningful educational benefit to students with disabilities. The purpose behind 504 is we give them an equal opportunity to access our education, essentially on a level playing field as their non-disabled peers. There are procedural safeguards under both and manifestation determination reviews under both. We'll get to those momentarily. So what are your procedural responsibilities under 504? First and foremost, you have to designate a person who's going to be your 504 coordinator. One of the hot topics that we have in our society and culture right now is sexual harassment and discrimination on account of gender. That's a Title IX issue. And so you have to have a Title IX coordinator because that's a civil rights issue. This 504 is substantially similar to that. You've got to have a person who's a coordinator who's going to hear complaints, which are grievances, that are brought under alleged violations of 504. So once you've got that 504 coordinator, you also have to have these grievance procedures. What are you going to do to respond to a complaint? How are you going to investigate it? Who's going to be responsible? Those types of things. You also have to provide notice of non-discrimination. We do this on our website, we do this in our student code of conduct, handbooks, etc. We basically tell people that we are not discriminating on account of various factors, including gender, race, national origin, and disability. So that disability piece is the 504 piece. You have a child find obligation under 504 as well as under IDEA. That means you have a duty to be proactive to find out whether or not students are students with disabilities. What that means is if you've got reason to believe the student might have a disability, you do not wait for the parent to request an evaluation. If you've got teachers who are suggesting that the student might be eligible under either IDEA for special education or 504, you need to do those evaluations, get the parent's consent, and move forward. You're required to provide notice of your child find responsibilities under both IDEA and 504 so that the public knows that you've got this obligation. You're oftentimes doing this through your ISDs, other types of marketing for the school, where you're letting people know that you've got this obligation to ensure that students with disabilities receive the same educational benefit as their parents. Basically, providing notice to parents when there's a dispute and how you're going to resolve that dispute. So the procedural safeguards are right here, as I mentioned, the notice. The parents also have the right to examine relevant records. They get an impartial hearing in front of an impartial hearing officer to resolve their disputes. They have the right to be represented by counsel at their expense at a hearing, and then they get a review of that procedure before a hearing officer. A lot of times, go ahead with the question.
You brought up a good question. So it is state law that each time a kid, a 504 or a IEP, and they are suspended, that they receive procedural safeguards each time?
Mm-hmm. Correct. Yes, they will receive those safeguards each time. There's going to be a distinction. We'll see it a little bit later between kids on an IEP and a 504 plan when it comes to suspending them and what we do potentially. The manifestation determination is the same, but the level of FAPE provided afterwards is different. But they're going to receive notice of their procedural safeguards each time you're going to be suspending these kids. And they would receive a manifestation determination each time you're going to do it. So for example, we'll talk about this a little bit later, but if you had a student who engaged in a particular type of behavior, say stealing, and we decided that it was not a manifestation of their disability because they were learning disabled in math, and there was no correlation between stealing and their learning disability, you can continue to suspend that kid. If the kid steals again in the future, and you want to suspend them again in the future, you're still going to conduct that manifestation determination, even though you're probably going to come to the same conclusion.
Now, my next question about the procedural safeguards is, okay, kid is suspended, parent comes up, leaves, don't get the safeguard. You know, I mean, what is there a time frame to saying, okay, we're going to mail it?
Yeah.
And because I'm saying, if you know, we had a parent who didn't, who left, but then said, well, you didn't give it to him.
Right.
It's like, okay, we're playing the game, right? All right.
Correct. Yeah. So the issue is like when you provide notice, and typically you might want to provide it in person, but the parent might leave before you hand it to them. You would want to send it out. You could send it out via certified mail, which would show that it was actually sent on this particular day, and you've got a receipt of the mail. Because we do have parents who won't pick up their first class mail or say that they never got it, etc. So sometimes we'll do the return receipt requested to show that they actually did sign for it. Even then, some parents aren't going to sign for it.
So like I said, something happened yesterday, they walked out and we mailed it today. We're clear?
You'll be clear in terms of having provided the notice.
Okay.
There are other issues, again, in terms of whether there was like the impartial hearing, etc. But yeah, you'll be able to show that you have provided notice. You want to keep a copy of that, indicate how it was, we usually in the law say served, whether it was personal service, first class mail, certified mail, those types of things. And if you've got a parent who is somewhat challenging, again, you're going to want to make sure that you can prove that you sent it out. You can also send them as attachments on email as well.
I have a question.
Yeah, I recommend doing it, personally, I recommend doing it both via email and either certified mail.
Now, what about dropping it off at their house, taking a picture?
That's not, it's good, but you don't guarantee that they've received it. And again, we provide it, but dropping it off at their house, taking a picture, a parent could allege that you just took the picture and took the notice with you versus put it in the mail. And once you put it in the mail, it's literally out of your hands. Question?
Yeah, well, this is more so towards the students with IEPs.
Okay.
So, because when they're suspended, their suspension starts that day. So if a student, say a student throws a chair or gets into a fight today, his suspension will start today. And then say they only get a 1-day suspension, so that would technically be today, and they come back tomorrow. So what if a parent, because every time a student with an IEP is suspended, they have to get a copy of their IEP goals. So if they come back the next day, can the parent just get it that day if they forget, if they leave before
Before it's provided?
Yeah.
Yeah, they could. You could again send it to them via email and regular mail as well. And the same concept is going to apply with 504 kids in terms of, if they're suspended for a partial day on the day that they engage in misconduct, that counts as the first full day of suspension.
Mm-hmm.
And so that time frame kicks in at the same for 504 kids as IEP kids. If they haven't picked up the documentation of their goals or the procedural safeguards notice because it just forgot to hand it out to them, I would put it in the mail by the end of that business day.
One last question.
Sure.
I think I'll be good. Okay, so kid is suspended and comes back to school, which we know, of course, legally is not there, but the kid has an IEP. Can't get in contact with the parent. Are we still following his IEP, even though he's in the building, he should not be?
If a student under a 504 plan or a student under an IEP, if they're being removed from their placement for disciplinary purposes, and we've done a manifestation to determine that it's not a manifestation of their disability, there's going to be this divergence. Students on an IEP are still entitled to a modified free appropriate public education after 10 days of removal, if it's not a manifestation of their disability. Students under a 504 plan don't get any services because while they're entitled to a FAPE, there's no obligation to provide them with that FAPE outside of school because, again, 504 is a non-discrimination piece. So if the student engaged in misconduct that was not a manifestation of their disability, they can be treated as any other gen ed student under 504 and IDEA and be kicked out of school. Under 504, gen ed students don't get any additional support services, so the 504 kid doesn't. IDEA is an education statute. We still have to provide supports and services to provide a modified free appropriate public education for the kid on the IEP, even while they're on that suspension out of school, even if it's an expulsion situation. So now if the kid comes back to school, and you're saying they come back to school before they're supposed to be back to school, because let's again use the example of a kid who's been expelled. Maybe they brought a weapon to school and it wasn't a manifestation of their disability. A kid under IDEA has no right to come back to school until the expulsion's over. A kid under 504 has no right to come back to school until the expulsion's over. Kid on an IEP under IDEA gets those supports and services to make progress on the goals and objectives in their IEP outside of school in an alternate setting. Kid on a 504 plan gets nothing.
So
but they're not allowed to come back to school. If they come back to school, they're trespassing.
We have a kid who's categorized as qualified as emotionally impaired and do something inappropriate, like touch a young lady inappropriately. Okay. Now, I guess it gets tricky in saying, to me, unless we say he has problems with distinguishing between, how do we determine that that's not a manifestation? Well, they would just kind of see what I'm
doing. Yeah, I see what you're saying, and we're going to get to the discipline a little bit later, but I'll just touch on this real quick.
All right.
The decision in terms of a kid who's been qualified, for example, that would be under IDEA with an IEP because they have an emotional impairment, fits within one of the 13 categories. The decision as to whether or not the misconduct was caused by or have a direct and substantial relationship to his disability is not made by the building administrator. It's made by the IEP team or the 504 team. So it's not your decision alone.
I mean, yeah, I'm well versed. I understand that.
Yeah.
I'm just saying that sometimes I'm just questioning,
Well,
you know, go ahead, you know, whether like, I'm like, how?
Yeah. Because even with EI, there are, what, 3 or 4 considerations as to why the student is EI. So if one is because of a pervasive mood of depression, then you would say, well, does touching inappropriately have to do with a pervasive mood of depression? If it's inability to form relationships, does it relate to that? So you're connecting it to the specific disability.
For that specific student.
Right. And that, when you said this, second one, you know, that's a broad umbrella, and that, you know, inability to form relationships. That doesn't mean I didn't know the touching was wrong.
Mm-hmm.
I may just can't. I may have inappropriate ways of, you know, like, you know, I'm quiet, or, you know, I get angry, or, you know, I'm accusing people of saying stuff that's not there, but, you know, I still interact and talk to people, but sometimes, you know, I may think that you're messing with me when you're not.
That's why it's an IEP team decision. You get to hear all that discussion in the meeting, and then the team makes a decision. Yeah, because it could vary from one student, it might be, and another might not be.
And we will be getting to student behavior and discipline a little bit later. Just going to try to get us a little bit back on track, and feel free to raise some of those questions as we get back a little bit later. The concept under 504, again, is that it is a non-discrimination statute. It is going to apply to students with disabilities, whether they qualify under IDEA or not, in order to level the playing field to give them an equal opportunity to participate in the education as their non-disabled peers. And so typically, the Office of Civil Rights won't be looking at the particular 504 plan that you have and whether that's appropriate. This is distinguishable from IDEA and IEPs, because oftentimes parents are going to file a due process complaint under IDEA saying that the programs and services don't provide a FAPE because they're not appropriate. And the hearing officers will be looking at the appropriateness of the IEP. What Office of Civil Rights typically looks at is whether you are following the proper process and procedures, whether you are in fact looking at whether or not the student has a disability, whether you've followed the evaluation or not, whether you've been providing the safeguards, whether you are yourself discriminating against the kids or allowing other students to bully them, harass them, etc., based on their disabilities, or whether you are retaliating against the parents and the kid because they've filed an evaluation for 504 or other types of things. So as I mentioned, you have a child find obligation. The child find obligation under 504 is substantially similar to your child find obligation under IDEA. The definition of a disability under 504, as I mentioned earlier, is much, much broader. The definition of disability follows the Americans with Disabilities Act, and that is any physical or mental impairment that substantially limits one or more major life activities. That's the key thing that we're going to be talking about. Disability also includes a record of having such an impairment or being regarded as having such an impairment. And I'll provide that distinction for you. Those last two bullet points are going to apply to situations of basically discrimination if you're discriminating against people in those accounts. So I'm going to tell you a quick little story about my sister, Melanie, who graduated as valedictorian of her graduating class in high school from Bay City Handy, and me. My sister, Melanie, and I are only 11 months apart. I'm younger, but she was 2 grades ahead of me. My father was an educator. He wanted to make sure that I was 18 when I graduated because boys mature slower than females. He wanted me to be both academically and athletically prepared for high school and graduate at the age of 18. Melanie graduated when she was 17. Melanie used to tease me when we were little that I flunked preschool because I was in preschool for 2 years before moving on to kindergarten. So Melanie would tease me that I flunked preschool. That is being regarded as having an impairment. I did not have any impairment at all, I promise you. Perfectly fine. My dad just wanted to make sure I was 18 when I graduated. But Melanie regarded me as having an impairment by saying that I was dumb and flunked preschool. Melanie, on the other hand, had a speech impairment and was in special education from 1st grade through 3rd grade because she couldn't pronounce, in particular, like her R's. She would say one instead of run. So when she would tease me of flunking preschool, I would tease her of being special education. She graduated valedictorian. She was only in special education for that 1st through 3rd grade period and then was gone. So her impairment was gone, but she would have a record of impairment. If you were to pull out her CA60, it would show that she was in special education for those years. And even though she's graduated #1 from her class, she's got that in there. That means as a high school senior, she's not on any kind of 504 plan or anything else because there's nothing we have to do to level the playing field for her at that time. But if, when she's up there giving her valedictorian speech, everybody's shouting out these horrible names about her being in special education and using the R word or anything, that's discrimination as a record of impairment. And if they're shouting out at me when I'm giving my speech because I was regarded as having an impairment, even though I didn't actually have an impairment, that's also discrimination.
May I ask a question about that?
Sure.
Regarded as having an impairment. So the question involves students who behave in a way that as lay folks, we think is consistent with bipolar disorder. But we're not in a position to diagnose, so how do we, in our child find, say that I think this child needs a 504 plan because he has whatever that terminology is regarded as having an impairment because of his behavior.
When you've got educational officials, whether it's teachers or building administrators, who look at a student and say, I suspect this student has a disability, whether it's a disability under IDEA or 504, what you should then be doing is meeting with the parent and saying, we suspect that your child has a disability. And we would like to evaluate your child to find out whether or not they would be eligible as a student with a disability under IDEA, in which case they'd get an IEP, or whether they're eligible as a student with a disability under 504, and they could get a 504 plan where we would make accommodations for them to ensure that they receive a free appropriate public education and an equal opportunity in the school. And the parent may or may not consent to that. If the parent does not consent to that, you could do one of two things. Go to a due process hearing to have a judge order that you do the evaluations, or you don't do the evaluations at all. And if you don't do the evaluations at all, after the parent has refused to provide the consent, you will not be liable for failing to provide FAPE. But if kids are harassing this kid whom you regard as having a disability, and you don't prevent that kind of harassment, you could be liable for violating their rights under 504, even though they have not been found eligible under 504 because the parent refused to consent to that evaluation. Because that is discrimination on account of a disability, and you have regarded them as having a disability. Correct.
Wow.
So in order to understand disabilities, we need to understand what a physical or mental impairment is. It's up here on the slide. And this is not an exhaustive list, but it's basically any kind of physiological disorder. It can include neurological things, so it doesn't have to be physical in the sense of somebody who has problems with their skeletal system, muscular system, and what have you, but it could. It could also include mental faculties. Let's go to the slide, sorry. I was going to go too far ahead. Episodic impairments historically would not be included. And an episodic impairment means that it happens at particular times, such as like depression, where you might not be clinically depressed all the time, but you might suffer from it from different times. Seasonal affective disorder, for example. Historically, that might not have been counted as a disability, but the Americans with Disabilities Act was amended in 2008 after a couple of Supreme Court rulings where Congress wanted to make more people disabled. I mean, literally, that's what they were doing. They expanded, if you will, the definition of disability, and they wanted the focus of the courts not to be on whether or not the person had a disability, but rather whether or not reasonable accommodations were being provided. So when the act was amended, the Americans with Disabilities Act said that if you have an impairment, mental or physical impairment, that is either in remission, like cancer that's in remission, or episodic, such as having epilepsy or seizure disorder, even if the student is not yet experiencing that, if it limits a major life activity, that's going to count as a disability. So these kids, for example, who might be allergic to bee stings or other things, they have a disability. They're going to be on either a 504 plan or a health plan to talk about what we're going to do in the event they get stung. Same thing with kids who are allergic to peanuts, those types of things.
What do the two A's stand for beside ADA?
Oh, Amendments Act. So it's the Americans with Disabilities Act Amendments Act. That was in 2008 and then was effective January 1, 2009. So that's why it's like the ADAAA. We still will typically call it the ADA, but it was this amendment back in 2008 which wanted to expand the category of people who have disabilities. Temporary impairments are not in and of themselves going to be a disability unless there's a substantial limitation of a major life activity for an extended period of time. Congress was so kind that they did not tell us what an extended period of time is. And so this is something that you are going to have to consider on a case-by-case basis. You're going to be looking at the duration of the particular temporary impairment, and you're going to look at how much their major life activity has been limited. As an example, suppose a kid gets into a car accident and they've broken their pelvic bone and they're going to not be able to walk for an extended period of time. You're going to be looking at that. The major life activity, walking, it's severely limited. They can't walk. They got to be in a wheelchair. The duration is going to be 6 months. That could be considered a disability, and you're going to put them on a 504 plan until they recover. Suppose a kid is riding his bicycle and sprains his wrist and is going to be in a sling for 2 weeks. And it's their non-dominant hand, they can still write, what have you. Probably not going to be considered a disability because the duration is much shorter and it doesn't really limit any major life activities. Substantially limits is also not defined, and you have to make an individual assessment. Fortunately, the Office of Civil Rights has given us a little bit of guidance, not a whole lot, but it's basically saying it doesn't substantially limits doesn't mean you cannot absolutely do something, but you're looking in a particular individualized case to see what the condition is, how much it is limiting the person's ability to do the particular major life activity, which we'll get to in a moment, and is that something that is long-term, short-term, what have you. The mitigating measures, this is the glasses thing. Other than glasses, if mitigating measures will allow the person to do the major life activity, they're still disabled. So for example, you have a student who is ADHD. They are attention deficit hyperactive disorder, and they are put on Ritalin. And when they are on Ritalin, they are calm, collected, behaved very, very well. They're still a student with a disability. The medication in and of itself doesn't take them out of that eligibility categorization. A kid who has asthma and uses an inhaler or a puffer still is a student with a disability. Same thing with kids who have allergies, and even though the EpiPen will allow them to breathe, they're still a student with a disability. The only mitigating measure that keeps people out from having a disability are the glasses. And they might have a disability other than that, but the vision impairment that can be corrected with glasses or contact lenses means they're not disabled on account of the vision impairment. So this is the example that the Office of Civil Rights gives in terms of a kid with an allergy. They are still eligible under 504, even though an EpiPen or allergy shots would allow them to manage the impairment so they are not limited in their major life activity. What are major life activities? Well, prior to 2008, the list was pretty short. There were really only about 9 things that were listed as major life activities under the Americans with Disabilities Act. As I mentioned, in 2008, as a result of a couple of Supreme Court cases, which was focused on whether or not people had the actual disability, Congress, in a sense, overruled the Supreme Court by expanding the definition of major life activities to include all of these things, including sleeping, for example. And just this morning, I had a call from a school district where there was an issue of a kid who has been tardy, elementary school kid who's been absent and tardy. In the first semester, I think tardy 28 times, absent 25 times. And the kid's claiming to have a sleeping disorder. And the school district was saying, well, you know, they should just be here on time. And I'm saying, no, you're going to have to evaluate to make sure that they don't have a physical or mental impairment that substantially limits the major life activity of sleeping. Again, my son, junior in high school, he has a very difficult time waking up in the morning. And so we've been going over that too. I don't think he's disabled. I think he's just staying up too late.
Well, you're saying that to determine that without a medical diagnosis, how do we make
correct? And I'm trying to see where we've got that coming up too.
Okay.
It's going to be coming up in the evaluations, really, really quick and short. Okay, we'll start talking about that because you're right. Like with ADHD, again, as educational professionals, we cannot diagnose a kid as having ADHD. No. We can diagnose a kid, or through the information that we have, we can say that based on the information we have, well, we can't diagnose them with ADHD, and so they might not rise to the level of OHI because we don't have that medical diagnosis. Right. We might find that the kid has some kind of a physical or mental impairment that substantially limits the ability to concentrate, think, or communicate. So the kid appears to us to be hyperactive, appears to us not to be able to focus. We don't have the diagnosis of ADHD. That doesn't mean we can't find them eligible under 504. We might still find them eligible, even though we don't have that medical diagnosis, and we'll get into that in a little more detail in probably about 5 minutes.
I'm just wondering what we just think the kid is bad.
What's that? What if you just think a kid is bad?
He's just bad, man. And we want to, I think as educators, we have to be careful about, you know, sending the wrong message to kids and tell them you have a disability when, you know, sometimes that becomes a crutch.
Correct. And I guess one of the issues is in terms of a kid being bad, and even kids that are bad, they might have a particular neurological impairment that leads them to do certain things. Like I know Mr. James asked me if I was going to talk a little bit about today about safety, walkouts, violence, and I will towards the end. But I'll tell you the one thing that all these school shooters have in common is a mental health issue. That doesn't mean they're not going to be held responsible for their actions. But if kids have mental health issues that lead them to be bad, we need to try to help them with the mental health issue, provide them supports, services, accommodations, what have you, and not just say, dude, you're crazy, you're bad, somewhere else. We'll also talk like under idea, if as we were talking before, where you're talking about those kids who have a tendency not to keep their hands to themselves. And a kid might have an emotional impairment, what have you. And the kid who has an emotional impairment is sexually harassing his peers by basically engaging in criminal conduct, CSC 4th degree, touching the physical contact of peers or adults on their private parts, even over clothes, can still be considered CSC 4th degree. What we do, and if we have a team that determines, yes, that's a manifestation of the kid's disability, we can't remove them from the educational placement as a result of the disciplinary removal, but we're probably going to reconvene the IEP team to figure out what the appropriate placement is for this kid. Because it sure enough isn't in the general education environment where we're putting their peers at risk of being sexually assaulted on a daily basis. So we might have to think of a center-based program or something else. So it's done through the IEP team process, not in the disciplinary context. Learning is itself a major life activity, but it's not the only one you consider for schools. Kids can be eligible for a 504 plan even if their disability does not affect or limit their ability to learn. Those major life activities are not an exhaustive list. Congress wanted to make it very clear that these are some major life activities. You have to look at everything, not just the 30 of them that are listed. And if a major life activity is substantially limited due to a medical or physical or psychological mental impairment, the person is going to be considered disabled. So your evaluation and placement process. You, as I mentioned earlier, are required to evaluate if you believe the student may have a disability. So that's part of your child find obligation, even if the parent has not yet requested an evaluation, but you suspect the disability, you've got the obligation to seek consent in order to do the evaluation under IDEA to see if the kid qualifies there and gets an IEP, or do the evaluation to see if they qualify under 504. You're required to do that evaluation before you create the initial placement, before you create the IEP or 504 plan, and before you do any change in placement. If the parent requests the evaluation, but you don't suspect the disability, you could refuse and then provide the procedural safeguards notice. As I mentioned with that sleep disorder, that's where the school district was particularly going. They're saying, well, we don't really think there's a disability. And I said, well, you may still want to do the evaluation. If you don't, you give them the procedural safeguards notice, and they might be able to file a complaint against you. In which case, based on the information you've provided me thus far, it's going to be very likely that you're going to be ordered to do the evaluation. So if you don't think it is, do the evaluation and rule the kid out.
And then they go back and say, do an appeal. And I mean, I've had the state come in and say, okay, he's given an IEP for 504.
Correct, yeah.
He doesn't have a medical diagnosis of kind of like.
Right. The medical diagnosis is not a necessary or sufficient cause for being found eligible. And what I mean by that necessary and sufficient, it's like a logical term. It's not necessary. You do not have to have a medical diagnosis in order to be found eligible. So in other words, you might find a kid eligible for a 504 plan, even though they don't have any medical diagnosis that specifies a particular impairment that substantially limits a major life activity. And you might still find them eligible as a student with a disability based upon the information that you have. It's not sufficient in that even if you have a doctor finding a medical diagnosis of something, doesn't mean that they're automatically entitled to a 504 plan or an IEP. Doctors a lot of times think that they can write prescriptions for certain educational services. It actually doesn't work that way. The decision is going to be made by the IEP team or the 504 team in terms of what placement is appropriate based upon all of the information, including a medical diagnosis or lack thereof.
I have a question.
Yes, sir.
If a student has ADHD,
Okay.
And is having a difficult time adjusting in the classroom, does that make can a 504 be started on the student?
The question is, if a student has ADHD, has a difficult time in the classroom, can we start a 504 on the student? Yes, you would do the evaluation. So like, it might be the teacher, based on the observations as we see here, thinks this student is struggling in terms of concentrating, thinking, getting his or her work done. I want to do the evaluation to see whether they're eligible. ADHD could be something that's qualified under IDEA as OHI, other health impaired, if it affects the student's academic progress, etc. And so they might even be eligible to get an IEP. If they're not getting an IEP, students who have ADHD, and you've got the medical diagnosis of that, because we can't diagnose a kid as having ADHD, but they come in and they've got a doctor who says, yes, kid has ADHD, they're going to have a disability. And we're then going to probably put them on a 504 plan, depending on what it is, to ensure that we're not discriminating against them and giving them an equal opportunity to access the education. What that 504 plan might be, because it might be that if the kid is on his meds, he's on his meds and there's no problem, we might think, well, we don't necessarily need a 504 plan. We would still want to be able to identify this kid, because we can't now discriminate against the kid in terms of discipline if the kid is engaged in a particular activity that is caused by or has a direct and substantial relationship to their disability. So the 504 plan might be as simple as the kid will take his meds before school, the kid will take his meds at lunchtime, something similar to that, but we would want to identify that kid.
On the meds issue.
Yeah.
What if parents let their child's prescription expire? Kids come to school without medication, and the behaviors are so extreme. Does your 504 plan have to address students who are unmedicated?
Your 504 plan would be addressing the individual student. And if the student is on medication, it could acknowledge that. If the student is typically on medication, the student hasn't taken it, and the kid engages in some misconduct at school and has failed to take their medication, we're not going to be able to do like a disciplinary change in placement. It puts you in a very difficult position. I don't think the general public necessarily understands that, how difficult it is to be a teacher or a building administrator, given everything that you're dealing with. But even in that situation, when you've got the student where they have that disability of ADHD and they're supposed to be taking their meds but don't, the 504 plan could address it, but you cannot compel kids to take medication. Right. And you can't say you don't come to school unless you take your medication.
I'm sorry, just a follow-up on the 504. Okay, so I have a case or a situation where a student has ADHD, but the mother does not want a 504 plan on the student. So we are coming up with an alternative plan. Is that okay? Is that
So the question is, you've got a student with ADHD.
Yes.
You've asked for consent to do the evaluation for a 504 plan, and either they've given consent, you found them eligible, parent says we still don't want a 504 plan, or they refuse consent, and we haven't even done the evaluation. And then the student still needs some services. We can do a behavior plan. Yep. We can do interventions. We're doing the positive behavior interventions in sports school-wide. We can have this kid even like in a level 2 targeted interventions group, if you will, through a behavior plan. Because the behavior plan is distinct and separate from the 504 plan or IEP. We can have it for that kid, even though the parent hasn't consented to a 504 plan. It's not necessarily providing accommodations for them. Yes. It's to address the particular behaviors. If they have refused consent for the IEP or 504 plan, and then we're going to be disciplining the kid, and the parents, we've got documentation, they refuse consent, we treat them as a gen ed student, which means we can kick them out of school, regardless of whether the misconduct was caused by or have a direct and substantial relationship.
So they don't exactly need to have a 504, not specifically have a 504 plan.
Correct. And this becomes very important for school administrators to understand, is even if kids don't have a disability, but they're engaged in certain behavioral conduct, you can create behavior intervention plans for those kids. In various interventions, modifications, etc. for those kids, even though they're not disabled, gen ed kids. And again, like 504 is generally considered general education. Right. It's in the general education environment. Even if the kid doesn't have the 504 plan, but you've got concerns with kids, you can put them on behavior contracts, and you can put them on behavior intervention plans, all of those types of things. These are possible evaluation triggers. If you see some of these types of things, this kind of throws a flag on the play and tells you, hey, we might want to seek consent to do an evaluation to find out whether or not the student has a disability. one of the keys, especially after the Americans with Disabilities Act was amended, are these food allergies and health plans. We've had a lot of school districts who had kids on health plans, and really they should be on 504 plans. Again, other things to consider is when you've got kids who do exhibit signs of being hyperactive. They're restless in class, they don't pay attention, they're disorganized. That might be something where you would suspect the kid has some kind of impairment that limits the major life activity of staying organized. Communication, social skills out as well. What you're looking there is to see whether or not it's proportionate, if you will, to the kid's grade and maturity level. So we might see some kids at a certain age where they're engaged in certain behaviors that are developmentally appropriate and they're kind of going in line. Then you see a kid, going back to like a school shooter example, some of these kids are still sleeping with their parents at the age of 15, 16 years old because they're afraid of the monsters under their bed. Well, when a kid's 5 years old, that might be normal. When a kid's 14, 15 years old, that's not normal. That's kind of a symptom of having a psychosis. Not that you're sleeping in the bed with the parents and the kids, you might not necessarily know about it, but if you're at a meeting for a disciplinary thing and the parent brings up this fact, you know, I just don't know what to do. I'm not getting any sleep because the kid's in my bed all night long, and it's a 14-year-old kid, that's a trigger. It says, well, let's conduct an evaluation because your child might have a disability, and let's kind of flesh that out. Here's what the Office of Civil Rights says on ADHD through a Dear Colleague letter. Again, they're saying that that diagnosis may be evidence of a disability. It's not guaranteed to be a disability, but basically it's a presumption that can be rebutted that the student does have a disability. And you, in a sense, would have the burden to show, for some reason, that the ADHD does not, in fact, limit a major life activity. But if the parent is not going to be consenting to the 504 plan or an IEP, you're essentially off the hook. Even if kids are doing very well academically, and again, I'll go back to the sleep disorder thing. What the special education director said to me this morning is, you know, Dan, this kid is above the benchmarks, above average grade point average, exceeding the benchmarks on our assessments. I don't think there's any real reason to go forward. Doesn't matter. Even if the kid is doing well academically, if they have a disability, you still need to address it. So with ADHD kids, if they are doing well academically because they're on their meds, you still have to address it. They still may have a disability, but it's got that mitigating factor that's allowing them to do well. And absent that mitigating factor, or as their meds may be adjusted, they're going to struggle. And so you have to make sure that you're not discriminating against them and that you provide them equal access to the educational environment.
So would you say it's a good rule of thumb to, a kid doesn't qualify for an IEP, is it in our best interest, or any school district's best interest, to qualify them for 504 without finding yourself in some type of litigation with the state? Because if he doesn't qualify for an IEP, and we don't think that he qualifies for 504, how liable are we?
Which is a very good question. And so to phrase the question, if the student doesn't qualify under IDEA and doesn't get an IEP because they don't fall within one of those 13 categories, should we give them a 504 plan just to avoid liability? And the answer is no. You still want to make sure they qualify as a student with a disability, because we don't give out a 504 plan as a consolation prize for allowing us to evaluate your kid. You still need to find out whether or not the student is eligible as a student with a disability. As we're gonna be getting into it in a moment later, in terms of once we find them to be eligible, like having ADHD, what does that 504 plan look like? What are the accommodations? We'll talk about that momentarily. But if they don't have a disability, you don't give them a 504 plan because they don't qualify. As I mentioned before, kids getting good grades. Just because a kid gets good grades doesn't mean they don't have a disability. Going back to my sister in first, second, third grade, She did very well reading, she just had a speech impediment. She had a disability. She needed to have special education support services, speech therapy, to help her with that, so that when she graduates as a high school student at the age of 17, she's not still saying that I'm going to run to the store. And again, this is the OCR basically telling you grades are only one factor. It's not the only thing you look at. You got to make sure that you look to see whether or not the student is limited in other major life activities. Another caution in response to intervention. We are doing interventions for all kids in Gen Ed. You can't use that as a reason to delay conducting an evaluation of a kid, saying, hey, let's just wait till we go through all of these interventions. If a parent has requested the evaluation, or if you suspect the student has a disability, you need to initiate the evaluation process right away. You don't wait until you go through the whole process of your Gen Ed interventions. This is a case out of Florida where the district was found liable for discriminating against the kid for failing to evaluate on a timely basis because they were waiting to do the interventions first. This is a case.
So then, does that apply in special ed also?
Yes.
Because we've been as a part of the evaluation saying, well, first let's do 6 weeks of interventions and then get back together.
Especially in the situation where the parent has requested an evaluation, start the process and do the evaluation. Okay. If it's us as a district suspecting it, we might wait for the interventions to make sure that, yeah, that's a legitimate suspicion. Here, however, and again, this is more of a psychological issue than an educational issue. This is a situation where a school district was found to have violated 504 because the teacher suspected that the kid might harm himself, more of a psychological than educational issue. And so the district basically said to the family, you can't have your kid come back to school until we have a complete psych workup and make sure that they're not going to hurt themselves or others. Basically, the student was allowed to return after 9 days, even though they didn't have the assessment. Office of Civil Rights found that the school district violated this kid's rights and that they should have initiated the evaluation right away when they suspected that disability and kept the student in school. And so they had to go through this whole process, including compensatory education and a musical experience because the kid was denied that for those 9 days.
Okay, can we go back to
Yeah,
that?
we can.
What if the evaluation needs to include a medical evaluation, documentation from a medical evaluation? You can't, I guess you're denying fate by saying, get that evaluation done first. But then what do you do to protect the other students if this student is one who is,
Correct.
without question, someone that's a threat?
And to say without question is where I would go first. When you've got students who are especially verbally threatening others, you're going to engage in that threat assessment. And you're going to be looking at various factors to try to determine whether this is a high-level threat, mid-level threat, or low-level threat. You're looking at the particular student. You're looking at whether or not the threats are vague versus specific. You're looking at whether this particular student has the means to carry it out, access to weapons, what have you. You're looking at all those things to assess the level of the particular threat. This is talking a bit about whether or not we suspect the student has a disability. And in this situation, again, this was 2015. There's like a pendulum that sometimes swings, if you will. And as administrators, whether you're building level administrators or district-wide administrators, you're always balancing students' rights against security. Whether it's in terms of deciding to suspend or expel a kid, keep them in school, etc. And you might weigh this risk and say, okay, we are going to have to reimburse for the medical evaluation. So as you said, if we actually need a medical evaluation, we're paying for it. We had to give them compensatory education, including the musical experience. We might even decide, knowing this case is out there, we might decide, yeah, we're going to balance the safety of the 500 kids in the building against your right under 504. And we're going to keep you out of school until we can do this threat assessment evaluation and decide whether or not you have a disability. And if so, whether it comes under IDEA, we create the IEP, or whether it's 504, we create a 504 plan. And we will provide these things after the fact, but we're going to secure safety right now.
So
It's like a risk assessment, literally in terms of the threat of violence, and a risk assessment in terms of the liability. And you might say, on the sake of safety, we're going to ensure the safety of all of our kids, and we realize that we might have to be liable to pay compensatory education, but we're gonna rule for safety first.
and then could the comp ed be provided while the child is absent from the building, or is that something you have to wait? So you can provide home-based services.
Correct. So again, let's go back to the situation where a student is already evaluated and found eligible first under IDEA. And we decide that the kid is engaged in particular threats. And we think that the kid is, for example, a dangerous student. If it's a dangerous student, we have to go get what's referred to as like a Hanig injunction. And a court says that we can keep him out of school for 45 days. If the student has brought a weapon to school, we can take that kid who's on an IEP and put him in a 45-day interim alternative education setting, even without a judge's order. But while they're in that interim alternative education setting, we still have to be providing the 504, the IEP student with FAPE.
Right.
If it's a 504 kid, we don't.
So,
Yes, sir.
my question is, when someone's rights been violated under 504 span, is it just pretty much we all for educational time lost? Because I don't know, it seems like, parents, honestly, they always say, oh, I'm gonna sue you. And I'm like, as if they're gonna get this $1 million payout. I'm like, well, you're gonna sue us for your child? I mean, which we will provide them with them, but it's just, I'm wondering, is there cases where people are getting monetary?
There may be cases where there will be monetary compensation, because remember, it is a civil rights act.
Right.
So whether we are discriminated against somebody on account of their gender, their race, their national origin, or disability, those are violations of civil rights acts. And there could be a federal lawsuit. This was an Office of Civil Rights complaint. So the Office of Civil Rights can't award monetary damages. A federal court could. And so if they file this civil rights complaint with the Office of Civil Rights, you're looking at compensatory education. If they file in federal court in the Western District of Michigan, you could be on the hook potentially for compensatory damages, for exemplary damages, and attorney's fees, potentially. And that's whether you're discriminated on account of race, gender, national origin, or disability.
Exemplary damages.
Exemplary damages are basically saying, shame on you. So to create an example of you so you don't ever do this again. So the compensation might be $20,000 for additional education, but we're going to award $250,000 of exemplary damages so you don't do this again. So for example, tax law. A lot of times what you will see is the IRS will go against big people, athletes, entertainers, to try to set an example for us so that we pay our taxes. So they might go against a sports star or a musician who hasn't been paying their taxes. I think Willie Nelson got hit with tax fraud at one time, or not paying the IRS's taxes. MC Hammer, got hit, those types of things, so that you and I will pay our taxes. And they try to set that example through them to make sure that the masses pay their taxes. Here, it's setting an example to you and other districts, don't discriminate. And the federal judge has the authority to do that. Office of Civil Rights, not. Most complaints are going to go through the Office of Civil Rights.
What is determination? That's the parent?
The parent, yeah. Typically, you have to go through the Office of Civil Rights first in order to get a right to sue letter. And a lot of times we will try to either settle those things through mediation, or a resolution agreement that basically says this will be the sole and exclusive remedy that they have. Typically, with the Office of Civil Rights finds that there hasn't been a violation, they'll still give the person the right to sue letter, basically saying, we've investigated this, we found no violation, but you have the right to go to court and sue. But the parents are not required to do that. They have the right, whether under Title IX for sex discrimination, Title VII for race discrimination, 504 for disability discrimination, to go directly to federal court. And this is just a quote from the Office of Civil Rights in that particular case. As I mentioned, health plans, you got to be careful with those. Those might be a trigger that you need to do an evaluation to make sure that the student isn't eligible under 504. Don't use a health plan in lieu of a 504 plan. Some school districts have been sort of converting their health plans into 504 plans through the evaluation process. This is an example of a case dealing with a student who had a health care plan, and we were waiting for the student to come to school while we went through the whole process. The Office of Civil Rights found a violation, got into a resolution agreement where we committed to do 504 training, like this type of thing, to make sure that school officials understood what their responsibilities were, and then also the possibility of compensatory education. Here's the big piece, the revocation of consent for special education. There was an Office of Civil Rights letter, now about probably 20, 30 years ago, called Letter to McKeithen, that basically said, if a parent refuses consent for special education, like we go through the evaluation process, we find that the student is eligible for an IEP, and the parent says, nope, I don't want my kid to be labeled as special ed, I'm not going to consent to special education services. The letter to McKeithen said, you've got no right for a 504 plan then. The parent revokes consent under IDEA, no right under 504. There are court cases that are coming out now that kind of suggest that's no longer controlling. And the court is, in a sense, pardon the expression, going to trump the Office of Civil Rights. And so the best practice now is to evaluate and determine eligibility under both IDEA and 504. And you'll remember that first diagram that I have with the concentric circles. If we are finding a kid eligible under IDEA, they are automatically going to be eligible under 504. Reverse isn't necessarily true, because the kids that qualify under 504 might not have one of those 13 specific disabilities, but we've decided this kid has a disability. And so in that situation where we find a kid eligible under IDEA and the parents say, no, I don't want my kid to be labeled as special ed, make an offer for a 504 plan and have them reject that too. That covers your backside. Again, this is when the parent is making the request for an evaluation. You either have to do the evaluation to determine eligibility, or if you don't, you provide the procedural safeguards notice, and the parent has the right to take you to a due process hearing. The purpose of these evaluations are not only to determine eligibility, but then to determine what, if any, accommodations the student's going to need in the schools to ensure that they have equal access. This is going to be a listing of the evaluation procedures. Again, it's going to require consent. We're going to be looking at the information that is being provided to us. Unlike IDEA, there's no specific time frame listed under 504 for how quickly you have to turn around the evaluation. We use the 30 school days from IDEA here as well, because we figure that is a best practice and a safety measure. Your materials are going to have to be used properly, administered properly, and being tailored for this particular student in this particular school so that you can make the determination as to whether or not they qualify. Medical evaluations are not absolutely required under 504. So unlike IDEA in OHI, where we're going to need that medical diagnosis to qualify for OHI, we might still find a kid to be eligible under 504 even without any medical evaluation. Therefore, we can't require the parent to provide it. If we think a medical evaluation is necessary, whether it's the sleep study, an ADHD actual diagnosis, we are going to be responsible for paying for that medical evaluation. The flip side of that coin is we don't rely solely upon a medical evaluation. You heard me say before, it's not necessary, it's sufficient. This means it's not necessary, that it's not required. This fourth bullet point means it's not sufficient. The mere fact that a kid has a medical evaluation or diagnosis does not necessarily automatically make them eligible. This is a case dealing with a situation where the school was requiring the parent to provide medical evaluation, or excuse me, documentation for the reevaluation, and the school stopped services pending that. They were found to have violated the student's rights under 504.
I know you provided the example of like glasses.
Yeah.
Is there something else? Because I'm trying to think of, well, why would a kid have a medical diagnosis other than glasses? I can't really think of it.
Yeah, the glasses was talked about in mitigating measures. Glasses are the only mitigating measures that will remove a physical or mental impairment that substantially limits a major life activity seen from being considered a disability. So other mitigating measures, so suppose a kid has legs that are of a different size, and the kid has a mitigating measure of a shoe that is bigger so that they can walk around. Kid still has a disability. And so we might have to provide accommodations for the kid in gym class, PE class, whatever. Might not affect academics at all, but it's still a disability. And so it's, you know, even with the mitigating measure, still qualifies as having a disability.
So the 504 will be written for gym?
Could be written for gym. It depends on the particular kid. So as you're going through the evaluation process, you're trying to figure out what does that kid need to have equal access to the educational environment, the coursework, sports, etc. And we'll get to sports in a little bit later too, extracurricular activities. So like as we talked before, a kid that's in a car accident, breaks their pelvis, is going to be in a wheelchair for 6 months. You might do a temporary 504 plan that allows them to have access to the elevator, allows them to leave class 5 minutes early at transition time, things of that nature. It's what that particular kid needs.
How about if he has a hearing aid?
A hearing aid. A lot of times kids with the hearing aids are going to qualify under IDEA, may have an IEP. But yeah, if the kid has a hearing aid, going to be a disability. The mitigating measure of the hearing aid is not going to stop them from having a disability. And so that even though they can hear when they have a hearing aid, you might still have a 504 plan for them potentially. You might not need any accommodations. So let me, and I think there's probably going to be a slide on this, but let me address this right here. The mitigating measures don't stop them from having a disability. The mitigating measures might preclude them from needing any kind of accommodations. The only accommodation is make sure that you use your mitigating measure. So again, like the kid with ADHD, if the kid is taking their meds, they might not need any kind of accommodations in the class. If they're not taking their meds, we might have certain types of accommodations for them, etc. But they might still be on a 504 plan in order to provide them with protection if they engage in this conduct. You have a question?
Is it possible to put, if a student already has an IEP and they qualify for 504 for a disability that's unrelated to why they have an IEP, can that information be another consideration on the IEP, or is it okay to have an IEP and the 504?
You would just have an IEP. Very good question. So the question was if a student has an IEP and then they also have another disability that doesn't impact their education or whatever, you would put that in additional accommodations. You put that within the IEP. You wouldn't have both an IEP and a 504 plan. You would write those accommodations, additional services into the IEP. Yes, sir.
Yeah, I have a question. If a student, let's say he's another student, and the student needs to go to the hospital or, you know, the doctor or whatever, a parent asks me, who is going to pay for, you know, for the bill? Is the school going to pay? Who is going to pay?
Yeah. The question is when you get a situation where a kid gets injured at school, maybe it's one kid hits another kid, and we need to send the kid to the hospital in an ambulance. Who's going to pay for the ambulance? Who's going to pay for the medical
Or
issues.
even if the parent takes the student to.
I've had that situation come up before, like an emergency situation where we had to call an ambulance. When I was working at a school, a kid got hit in the head with a baseball bat, split his head open. He was out for like a minute or two, came back. We called the parent and 911. The EMTs came. Parent finally called back and said, no, I'm going to come pick my kid up. And the EMTs are saying, no, this kid needs to get to the hospital right away. Explain to the parent, meet your kid at the hospital. We're going to send the kid in the ambulance. And the parent's irate, like, no, I'm not paying for that. You're going to pay for it. Like, yeah, we'll address that later. Your insurance might cover it. It might not. I honestly don't know who's ultimately going to be responsible for paying it, because there are a lot of people who are uninsured. It may be covered through your insurance. It may be that the parents then want to sue you for the injury that occurred at your school because they've got these medical bills, etc. And you've got governmental immunity for certain things unless you engaged in wanton willful misconduct. That's something that can get sorted out later. And I apologize, I don't know right off the top of my head whether the school would ultimately be responsible for that. I don't think that you would be. But what I've typically told parents in that situation is, look, we will address that later. We've got medical professionals who are telling us your child needs immediate medical attention. We're going to make sure that that happens, because if we don't, we're overruling the medical professionals, and that would give rise to gross negligence, wanton willful misconduct, and then we'd be responsible for what happens after that.
Yeah, because a parent asked me and I didn't know what to say, because I was under the impression that the student who hurt the other student, I mean, the parents of that student should be responsible for covering, but I didn't know. I mean,
We might need to check with the business office, because we have to make sure that the incident report is filled out. And then if the parent takes a child to the doctor, there's a place on the incident report to fill that out. And I think the business office handles the insurance part of whatever happens with students when there's an injury.
okay.
That would be good to know.
Yeah.
Yeah.
This slide is, again, just a reminder of what that process is. There was a slide before with the same material. It's just, again, a reminder as we get ready to move on. Once we determine that the student is eligible, we are starting to take all this information to try to figure out what the appropriate placement is for the kid. And we're going to be getting into that in just a moment. But again, if we find the kid ineligible, we're providing notice to the parent and the procedural safeguards so that they can seek to challenge it. The team that's making this decision in terms of both eligibility and then what services or accommodations are necessary is similar to an IEP team. We call them a 504 team, and it's going to be people who are knowledgeable about the student, who are knowledgeable about the assessments that are done and all the data, and knowledgeable about what accommodations would be available. And so if we find the student eligible, we are required under both IDEA and 504 to provide a free appropriate public education. One of the things, as I mentioned earlier, it is general education. It's in the general educational environment. But the definition of FAPE under 504 specifically includes special education related services. And so it's a difficult thing. We cannot deny it. So you may have a situation where a student does not qualify under IDEA for an IEP, yet if we determine that they actually need special education in order to get a FAPE under the 504 plan, we're going to be required to provide that for them. It then gets into a business issue as to how we're funding that, because the IDEA funds aren't supposed to be spent on the non-IDEA kids. Again, don't deny the special education. That's just what I was saying right there. If the kid needs the special education, you need to provide that, even though this is Gen Ed. If you decide that no supports or services are needed, you're not required to provide FAPE. You would document that the kid is eligible, but no services are needed, no supports are needed, no accommodations are needed. The kid still has protection under the non-discrimination issues and, again, potentially with the manifestation determinations. So going back to that mitigating measures issue. If you decide this kid is eligible as a student with a disability because they have ADHD, but when on mitigating measures such as medication, the kid needs no educational supports, services, or accommodations, you would create that, find them eligible, and indicate in the plan that nothing else is necessary. FAPE is not required for those 2 bullet points that I was talking about, my sister and me, for those students who are regarded as having an impairment or have a record of actually having an impairment. They no longer currently have an impairment, and therefore they don't need FAPE, but they are still protected by that non-discrimination, as I said, towards the beginning of the presentation. Your 504 plan should be reduced in writing. It would identify any particular accommodations or services that the kid needs in order to have equal access to the educational environment. You're going to have that plan signed by the parent, signed by the school official, and then provide them with the procedural safeguards, notice, and review that plan as needed.
May I ask a question?
You may.
Do you all have a template? We've been using one. I thought we got it from RISA, but RISA has something different. Did we get a template from Thrun Law Firm?
I know we have like a 504 with all the procedural safeguards and the template. I don't know if we've ever sent it to you, to be honest with you.
It's like 35 pages and it has links to the different forms.
Correct. Yeah, I know we have one like that. And I don't know if yours is up to date because we typically update it on a regular basis. So it might have been something that was provided 3 or 4 years ago. And
it was a long time ago. I'm wondering if we could get an update.
Yes.
And then another question is, on the accommodations page, if you type past one line, then the font shrinks and it's really hard to read. So is it possible to have it expand? And then another thing is, in some of the text boxes, if you type below the box, the arrow will still go down and let you type, but when you print, it won't print.
Correct. Yeah. What you'll want is the technology to work with you and for you instead of limiting you. So in terms of those like technological issues, again, I don't know what our form looks like right now and whether it would allow for that or not, but you would want to make sure all that information is available, not only in the electronic format, but in the printed format so that the parents can see it, so that the teachers can see it, so that substitute teachers can see it, all of those things, because all of us are going to be held accountable for that. And if we've got all these accommodations and it stops up here and we don't see this, we're going to be in trouble.
Can you send, I'm the coordinator for the district, could you send me that and then I'll distribute it to everyone else?
Sure.
And then also, another question, what is slipped my mind? Oh, when you're distributing the information to those who have a need to know, do you just give them the accommodations page, or do they get the whole evaluation summary and all of that?
They could get the whole thing. I mean, they don't need a full CA-60 necessarily, but they could understand what the disability is and what the accommodations are.
Okay.
It may help them understand the student a little bit better than just listing out these accommodations, because they now know the why of the what. You know, the accommodations are what do we do, and this explains why.
And so we have, say for example, at the middle school or the high school, there might be a half a dozen security personnel or safety monitors, and the student might have an accommodation where they can be escorted from one place to another. So I guess I'm just a little nervous about giving that level of confidential information to
everybody. Correct. It becomes this need to know, like who needs to know all the information. Like what was going through my mind is like sometimes we might have a student with a disability, and whether it's an IEP, 504 plan, they have a disability because they were like a crack baby or fetal alcohol syndrome or all these different types of things. And that can be somewhat prejudicial, if you will, where, you know, now the parent may have had issues back then or whatever, but you've got these people who are judging the parents and causing problems in the relationship. They don't necessarily need to know that. What they do need to know is, again, what the accommodations are. Teachers might need to know more than others, but if you've got a kid who's got certain accommodations, and anybody who's going to be interacting with that kid is going to need to know those at the very least. Like your security officers might not need to know the summary of the evaluation data, but they're going to need to know that we don't escalate this kid. These are the de-escalation things we are going to use. Substitute teachers are going to need to know those things too. They're not going to need to know the full history.
Okay.
The teachers with the kids generally are going to have access to more of the record than the people who are just sort of on the tangents dealing with the kid on a less regular basis.
We've had, this was a special ed student creating a behavior plan using things like if the student has extreme mood swings, do this, rather than say, and the child is diagnosed bipolar, but we avoid using the label.
Yeah.
But all of the accommodations kind of refer to characteristics.
Yeah.
But I've just always been a little concerned about sharing too much
Correct.
information. But then if you want them to have the accommodations, you gotta share some.
Exactly. And anybody who's going to be interacting with that kid is going to need to know those accommodations because as we'll see in the disciplinary context, and I'll say it now, is like with IDEA in an IEP, what we're looking at is whether or not the misconduct was caused by their disability as a direct and substantial relationship or our failure to implement the IEP. And if the behavior plan, for example, is part of the IEP, and we've got things in there that are trying to de-escalate the kid, and we've got a substitute teacher who is not aware of the accommodations, and the kid goes off the rail because, hey, I'm supposed to get this accommodation. The substitute teacher says, sit your butt down. You're not getting this accommodation. The kid says, no, I get this accommodation. And you end up with a situation where the kid might even hit the substitute teacher, which is physical assault on school personnel, which historically has been a mandatory permanent expulsion depending upon whether the kid's in grade 6 or above. But it was our failure to give the kid that accommodation that led to all of that. We're not able to suspend or expel the kid.
So are these, do judges, when these kids, get in trouble in school, where they actually break the law, do they consider these kids with disabilities? Because the parents don't care, Right? I don't care. I mean, and it's not like, you're going to say this kid has a disability. It's like, he's a kid, he did this. What y'all gonna do about it?
And are you talking like in a criminal court of law or?
In a criminal court of law.
Yeah, it really depends upon the nature of the crime itself. Some crimes require specific intent, like murder requires the intent to kill. Right. Negligent homicide doesn't. So the prosecuting attorney and or the judge is going to decide, okay, did this kid have the mental faculties to intend to kill somebody, or was it negligent? Because the kid still has a duty, and we're going to deal with it. And we might decide then in the sentencing piece whether the kid goes to prison, whether the kid goes into some other kind of treatment facility. So, for example, John Hinckley Jr., that's the guy that shot Reagan, right? I'm trying to remember, yeah, because he ends up in a mental facility for a while, like a psychiatric facility for criminals. He's no longer roaming around society, still locked up, but because of his mental illness, that's where he's placed. That's what the judge is going to be looking at. They're still going to be held responsible for committing the criminal act, but the sentencing might be a little bit different. Do you have a question?
No, it triggered something else, but it might be off topic, so I'll give it to myself.
Sorry.
Go ahead.
Can we go back to the sleeping disorder?
Sure.
I have a student who comes in late frequently, and he was seen today walking to school. He's 11 years old, and he walked it's 5 minutes from the school to his house, but in car. For walking, I don't know how long it would have taken him to get to school.
Sure.
The secretary saw him and said, "Oh, that's one of our students." So she picked him up. My question is, Can we get in trouble for that? He's missing the bus. He gets late to where he's picked up, so he walks. He rides a bike. Does whatever he can to get to school. So I mean, my concern is, can we get in trouble for that? I mean, is it our responsibility to? If he's
It's not your responsibility to wake a kid up and get him on the bus. I've actually had this go before the Office of Civil Rights one time, where a parent basically said it was the principal's job to get the kid up, get him breakfast, and get him on the bus. And the Office of Civil Rights said, no, it's not. But if the kid actually has a sleep disorder, you might make accommodations in terms of them coming late, potentially, that's not going to adversely affect their grade. It becomes difficult because if the kid is late and missing class, and what level are you, elementary?
he's
You said 11 years old, so I'm assuming.
yeah.
Yes, it becomes difficult because if they miss that educational piece, they're going to fall behind their peers.
Well, then it really becomes a neglect case.
And that's what I was going to say in terms of
Yeah.
some of that too, is, depending upon the age of kid, et cetera, 11, should they be walking to school by themselves at that age or not? Do you suspect neglect? Should it be reported? Once you suspect neglect, you've got an obligation to report it. It's up to Child Protective Services, Department of Health, Human Services to do the investigation and whether it's truly neglect. But if you think that it is neglect, you report it. You could, and when you said get in trouble, you could potentially get in trouble for picking the kid up and driving them. And when I say could potentially get in trouble, if the kid now alleges that your secretary abused him, they're the only two in the car. If there's a car accident, on the way and the kid is killed, mom's like, I had the kid walk. What'd you do picking him up? All those things, it becomes a slippery slope.
Yeah.
Well, we have a kid, same way, 8th grade. Dad comes to school every day late. I mean, one day he dropped his kid off at 2:30. We got off at 2:40. I mean, he literally walked in and turned around and was like, I said, sir, we can count if we wanted to.
Wow.
And so Dad says, it appears to be that Dad may be a little challenged. And so, but we asked Dad, why is he late? He said he had trouble waking him up in the morning.
And it very well could be that Dad had trouble waking Dad up in the morning.
Yeah, so,
But yeah.
Hindsight, and hearing this, what with him, and we said it was a medical diagnosis that his son had a sleeping disorder. I'm wondering what kind of 504 plan could we write, especially if he's bringing the kid in at 2:30.
Correct. And that's the thing, it's like this bullet point here, being individualized. Your assessments, your evaluations to determine eligibility, and then what supports the service you're getting is based on the individual child, just as it is under IDEA, where we're looking at the particular student. And what does this particular student need in order to level the playing field, to have an equal opportunity to access it? Because that's
But
what
it
we're
has to be
seeking to try to do.
reasonable, I'm assuming. I mean,
Correct.
because you can hit a lot, and there is a lot. I can say, well, we're going to teach him at 12, at 5 to 4 in the morning.
Correct.
Because he look at that time.
The difficult thing is as a parent, and how many of you are parents of children of your own, you start wondering how much of these accommodations become enabling for behavior. Is it really a disability that limits this or what? And so it might be that the accommodations for the kid, whether it's a sleep disorder or something else, you're looking at what that particular kid needs to have equal access. And it might just be that.
Though, not to cut you off, I just wonder how sometimes kids get labeled emotionally impaired without a medical diagnosis. To me, that sometimes, I'm like, how do you determine?
It's an
I
evaluation.
mean, I can understand the certain emotional impairments, depression, withdrawal, but a lot of our emotionally impaired kids are, excuse me, for lack of a better term, just bad. And they just say, well, he emotionally impaired, or he otherwise health impaired, or okay, well, he's socially maladjusted. I'm like, When did all this come about? They didn't have this when I was.
Well, there's specific assessments that are done to make those decisions. The special ed team from RISA goes through a battery of tests to make that, so.
And I
And
don't
then
have to
also
say, I didn't
I was
always
wondering-
agree with the outcome,
mm,
but they did. I understand that. I mean, and maybe it's my own bias. I don't know. Maybe not. I just grew up with the type of father say, no, you're gonna do right and that's it. You need medicine. I got some for you. And it wasn't the Bible.
Exactly, so.
But I'm just saying.
In
Yeah,
terms
I
of when
also-
things change, for example, the corporal punishment thing, there was a time when you could spank kids in school. Can't do that anymore. I mean, things have changed. The law has changed. We're gonna try to keep moving on somewhat quickly to try to get to some of the other basics. If you don't implement your 504 plan, the parents have the ability to seek redress in a lot of different ways. They can follow the grievance procedure in your own policy. They can take you to a due process hearing. They can file an Office of Civil Rights complaint. They can file a lawsuit. As I mentioned, they can file a lawsuit in federal court. It could result in individual liability of individual administrators and teachers if they've failed to implement the plan and have discriminated against the kid. And you might not have any governmental immunity as a result of that for violating their rights. And these are just a couple of cases. I'm not going to go into any detail about them, but in part to try to scare some people to show you that you have to implement the plan. Re-evaluations are supposed to be done periodically whenever conditions warrant or before you do any change in placement. Under IDEA, we're required to do a thorough reevaluation every 3 years. We suggest using the same type of time frame. Students who are transferring to or from another school, you follow procedures similar to a kid who's on an IEP plan. If the kid comes to your school with a 504 plan, you need to review it and either implement it if it's appropriate or conduct an evaluation if appropriate. And you might consider implementing the existing plan while you're waiting to find out whether or not the student is in fact eligible. So here's a checklist for you when you've got students who are transferring in, and make sure that you're following these procedures for transfer students. A couple of the hot topic areas are like the non-academic and extracurricular activities, both under IDEA and 504, because remember, kids who are eligible under IDEA get the 504 protections. You might have a kid who's on an IEP and there's a complaint that we violated 504 because we didn't provide accommodations in extracurricular areas.
Okay, I'm confused now.
Okay, but
So they have an IEP, but we didn't provide that 504 accommodations?
in a sense, yes. We can discriminate against a kid under 504 who's on an IEP. They don't have both a 504 plan and an IEP,
Okay.
but kids who are eligible under IDEA and get the IEP
Still have ADA.
still have all of the 504 protection.
Okay.
And so you can violate 504 for a kid who's on an IEP even though they don't have a 504 plan.
Okay.
And this is one of the areas where it comes up most, is in providing these accommodations outside of the educational classroom environment.
Okay.
And so it's in your clubs, your athletics, those types of things, where if a kid has a disability and he wants to be part of the chess club, or if a kid has a disability and he wants to be on the basketball team, what types of accommodations are you going to be giving them? You have to address that. 504 says you give them an equal opportunity to participate. That means if you have certain athletic programs that cut athletes, like in basketball is a typical one, where you're only going to have 10 to 15 kids on the team, you got 20 kids who try out, you give that kid an equal opportunity, doesn't guarantee that they're going to be on the team. Band, I had a situation where a kid had, I think it's called Prader-Willi syndrome, where they need supervision or they'll just eat and eat and eat. And so the kid had a one-on-one aide in the school. Band, when he got to high school, the band goes to camp for a week. And the school told the parent, your kid can't go unless you come. and chaperone your kid 24/7 in band camp. And the parent said, no, you've got to provide them a one-on-one aid. School called me and they said, you've got to provide them a one-on-one aid. You've got to give them that opportunity to participate just as the non-disabled peers. You don't put that burden onto the parent. But they have to compete for those teams just as anybody else would. And as long as you're not discriminating on account of the disability, the kid might get cut. So again, going back to the kid who's got one leg longer than the other, he's trying out for track. The nice thing about track is kids generally don't get cut. You run as fast as you run, you still get to run at the meets, but you probably aren't going to be winning any of the meets. You don't have to adjust the rules and give this kid a 10-yard head start in the 100-meter dash. No, the kid gets to wear the shoe that levels off, etc., and competes. But again, in track, probably not getting cut, gets to participate in it. Same thing with like cross country, other types of things. So we have to ensure that these students are participating in these activities on an equal basis as their non-disabled peers.
Okay. We have a young lady with is it a seizure disorder? She's an ACA, or she might just pass out and collapse. I forget what it is. No, this is at the high school. And the 504 leader there is concerned that you know, it might happen once every 6 months or so. Does that mean we need to always have an aide with that student at all times, just in case?
What it would mean is that the student is eligible for a disability, because again, this is episodic.
Yeah.
Which means that they're going to have a 504 plan. It means that your team is going to decide what accommodation is ultimately necessary. Doesn't necessarily mean that they get to have the one-on-one aid the whole time, but it might mean that we've got an EpiPen readily available in the classroom. It might mean that we've got not a one-on-one aid, but a classroom aide who's observing that kid as well as the other 20 kids in class, what have you. It's ultimately going to be a decision made by the team as to what that student needs in order to provide the equal access to the educational environment. And if the team decides that yes, a one-on-one aid is necessary, even though this only happens twice a year, that's what the team's decided. But it's based upon all that evaluation data, etc., and making that decision by the team for that individual student.
So then where's the liability if there's no individual student aid and something happens? How do they just have to figure out another way to support the potential for that to happen?
Correct. You through your IE, through your 504 process, your 504 team is deciding what supports accommodations this student actually needs. And they might decide that that's necessary, but they might decide that something else is just as appropriate. And again, if it's a seizure disorder or allergies or something that's episodic, they are eligible.
Mm-hmm.
But then we figure out what that accommodation is, and it has to be a reasonable accommodation. And you might say it's not reasonable to put a one-on-one aid with this kid.
Okay.
But what is reasonable?
Okay.
Let's kind of talk about it, figure it out.
Okay. Thank you.
You're welcome. There was a Dear Colleague letter that specifically talked about extracurricular activities. Again, that students have the right to equal access there. There's some examples on this. But basically, we're giving them that equal opportunity, that leveling of the playing field. We're not having, if you will, Special Olympics within the school, where we're creating separate programs for students with disabilities. Although we may make modifications in certain things, we may make modifications to make sure that the kid has safety. But again, that neutral participation criteria, if the kid isn't able to make the team, such as a basketball team, we're not obligated to put them on the team. They have to compete with everybody else on that equal playing field.
Hold up.
You said pulled up?
Well, I had someone call me.
All right.
When I was off work, and asked me, that was an advocate for a child who said, we need him to be on that team because he's going to act better. I said, ma'am, it doesn't work that way.
Right.
Well, we need him on that team because we know he's going to act better. And the athletic director, when I came back, he was on that team, and he was still acting up.
I've seen like an IEPs occasionally
Kid you not.
where they'll try to write into an IEP that the kid will participate on varsity basketball. Should not be written into an IEP at all. Absolutely not. They have the right to compete for one of those positions.
Right.
They're not guaranteed a spot.
I said, well, you know, it's and she went as far as I said, well, he didn't make it. Okay, you have to try out.
Right.
He didn't make it. So how do we justify him being on the team versus someone else who didn't make it as well? And then she was like, well, there's no special circumstances we can provide for this kid. And for whoever, he was on the team.
Yeah. You're not legally required to do that. You're not legally required to create a space for them.
On the team, how this
they compete. Yeah, they compete based on that neutral criteria. There are a number of sports that don't cut, though. And so a lot of times we try to encourage kids with disabilities to seek those opportunities, like swimming, track. You know, they're not going to be the standout athlete, but every time I go to my son's track meets, there are like 20 heats of the 100-meter dash, you know, and all these kids are running it, and God bless them for doing it. And it's great that they can be a part of the team. That's what the Dear Colleague letter talks about, is you learn a lot more from sports than just the sport. There's that teamwork, leadership skills, all those things. And we don't want to deprive students with disabilities from those opportunities. I learned a lot more about life playing football than I did sitting in a classroom, you know, to be honest with you. Some of the partners in the law firm I used to be in, you know, kind of wish that, hey, maybe they participated in some team sports too, to understand what it means to be part of a team, because you're just such an individual. Right. But sports like basketball, like volleyball, that can only carry a certain number of people on their team, aren't required to reserve spaces for individuals with disabilities. They use that neutral criteria to decide. Also, you don't have to do a fundamental alteration of the sport. And so you start looking at what does it mean to be a fundamental alteration. And so like in swimming, when you swim, you've got to touch both hands, right, in order to finish. Well, if you've got a kid who only has one arm, they can't touch both hands. That would not be a fundamental alteration of the sport of swimming to say a one-armed kid can touch with one hand. It would be a fundamental alteration, on the other hand, to say this kid gets to have flippers. You know, what are those things called on the bottom of your feet when, like, you know, to do that? Because now they're getting that competitive advantage. Or it would be saying to the kid, as I mentioned before, who might have one leg longer than the other, they get a 10-meter head start than everybody else. That's a fundamental alteration. You're not required to do those things. These are some shoulds that the Dear Colleague letter said. You're not required to do these things, but it's something that you might want to consider. The behavior and discipline. We can't discriminate against kids on account of their disabilities when we are dealing with their behavior. We're supposed to keep them in the least restrictive environment, and we need to make sure that we are not treating them and disciplining them for their disabilities. The similarities are under IDEA are essentially the same types of things when talking about students who are being changed in their placement due to disciplinary things. And that is any removal of more than 10 consecutive days or any removal of 10 or more cumulative days in a school year where there's a pattern of exclusion. And then we have to conduct that manifestation determination. Pattern of exclusions, we're looking at whether or not the misconduct was similar, how close in proximity the discipline referrals were, what the lengths of durations were, etc. The manifestation determination is trying to figure out whether or not the student is being disciplined for their disability. whether or not the misconduct the student engaged in was caused by or has a direct and substantial relationship to their disability. The big distinction between 504 and IDEA is this last one, this last sub-bullet point there. Under IDEA, a student who's on an IEP, if they engaged in misconduct that was not the manifestation of their disability, we are still required to provide them with a modified FAPE, provide them with supports and services so they can access the general curriculum and make progress towards the goals and objectives in their IEP. If a student on a 504 plan engages in misconduct that was not the manifestation of their disability, they get nothing when they're out of school. They get treated just like their gen ed peers. What we're doing now here in Benton Harbor is trying to give kids access to Odyssey while they're out of school. That's what you do with the kid on the 504 plan. But you're not sending a speech therapist or whatever to their home. Detentions. I was in front of an Office of Civil Rights mediator recently, and this one just threw me off. The general idea for a removal is that the kid is being removed from the educational environment. Detention say you come to school early or you stay after school. I've had one mediator for the Office of Civil Rights say that that's going to be considered a removal because it's disciplinary in nature. And I said to him, we're not removing the kid from the class at all. He said, I don't care. It's a removal. And I said, I disagree because they're not being removed from their classroom. They're going to class. They're just serving their discipline either before or after.
And that's a problem?
This particular mediator seems to think that it is. I disagree. We're just kind of putting this as a red flag up there. If you are giving non-disabled kids detentions before and after school, from my perspective, you're able to do that with disabled kids too. Here is another distinction. Under 504, kids that are taking drugs are not going to be protected. And so if you've got a kid who comes to school and he's on a 504 plan, not an IEP, and the kid is high as a kite, and you want to suspend him for possessing marijuana, you may do so. Because the Americans with Disabilities Act, Section 504, does not protect current drug users. 45-day interim alternative education setting is just the same as it is with IDEA. You can place the kid into this when they possess drugs, when they possess a dangerous weapon, and when they commit serious bodily injury.
I thought those were mandated expulsions, having a weapon.
They were mandated expulsions. In Michigan, again, now we've got discretion over mandated expulsions. And so that would be even if there is the disability. This next material deals with what happens if the parents disagree. Do you guys want to keep going?
Sure.
Or okay. As I mentioned before, if the parents disagree, they can file the grievance with your 504 coordinator. They can file a complaint with the Office of Civil Rights, or they can go directly to federal court. They have no obligation to first pursue the grievance, first pursue the complaint. They can go directly to court.
I'm just curious because these 504 plans are legal documents, and which could potentially get school districts and individuals sued. That I'm just surprised that we're not providing legal counsel or some type of counseling. I mean, because we're educators, and we're making medical determinations, and I mean, I just think it's a little bit kind of like, I don't want to use the word setup, but it's like, wow, because I know some people, even when we were a few years ago, we're trying to work with the SPED Ed team for RESA, and they was like, legally, I can't do anything with 504. Once I found that they're not ineligible, I can't legally work on the 504 plan. I said, but you guys have the expertise with determination, and this is really, I mean, it's not under the IDEA Act, but it's still very similar to an IEP.
They're probably saying legally, I can't work with that kid due to funding, in terms of the federal funding.
No, can't actually work on the 504. They can team,
Pardon me?
can't work with the 504 team.
Well, yeah, what I'm saying is they're probably seeing that because of
I
federal
got you,
funding.
what you said,
Funding
right.
of their.
So,
their,
Right.
So-
They're
right.
working outside of their job.
Right.
Right, okay.
So,
So should we call you when we need a 504 then?
you should call the 504 coordinator, who's going to be specified.
And she's gonna call you.
She may call me, she may have to call the superintendent. You know, I don't know, because typically school districts don't let principals call the attorney because it costs money. And so there's typically a hierarchy. I don't know what they're going to do. But part of it is you're having this training to try to understand what your roles and responsibilities are. I would not say that you make medical determinations. You make
What I'm saying, we're making a
eligibility
medical,
determinations.
right, and then we're providing accommodation for medical needs, which sometimes I feel that can be very uncomfortable when you're talking about a kid with a medical diagnosis and you're making a determination as an accommodation without being.
And the medical, when you get the medical information, it might be very limited. So what we've done is we Googled online, go to some MD doctor site.
Well, I've
that
asked that the
particular,
doctor provide us with what he recommends as accommodation.
Yeah.
I'm saying, you know,
But you
as
don't
a
always get that.
doctor,
Yeah.
what would you like for us as a school to
Mhm.
do? So I can have a leg to stand on, because I might, you know, may make a recommendation that he may see medically should not be appropriate.
Then be able to blame the doctor.
Right, well, I can say.
And he'll say,
this
well,
is
you're
a
the
rec-
educator, you handle that part.
I'm not a medical doctor though,
You are not.
and attorneys are very expensive,
Attorneys are very expensive.
very expensive.
Yeah.
That's why I use a Google medical site and you can sometimes put in like bipolar disorder accommodations in school. And it'll list
Right.
some
And
accommodations.
I would say you would use that then as a starting point to bring that to the 504 team to figure out which, if any, that individual
Applies to that
student needs.
particular child, yeah,
Exactly,
because they don't know.
The important thing on this slide, as I mentioned, you know, all of the routes that the parent has available to them, they're not required to do any kind of mediation through 504. Can be done, is not absolutely required. As I mentioned earlier on, you have to have a grievance procedure. That's going to be in your board policies, should be listed in the student code of conduct or other information that's going to the parents to ensure that the kid has due process. Impartial decision makers, those types of things.
Yeah.
You cannot require the grievance procedure before they go to a complaint to the OCR, before they do a state complaint, or before they go to court. Here's a checklist for what should be in your grievance procedure. And you can kind of check on that.
We may need a copy.
What's that?
We got the slide.
Oh, that's
Yeah.
right.
Yeah, you got the slide in when I provide you with the updated book,
It'll be in
if you
there.
will. Yeah,
Okay.
it's gonna have grievance procedures and everything in there. But it becomes important for the building administrator to review that, especially know who your 504 coordinator is, review those procedures that are in your board policy, etc. You cannot retaliate against the student or the parent because they've complained, testified, or participated in any OCR investigation. Any kind of retaliation isn't of itself a form of discrimination. What sometimes happens is a parent might file an OCR complaint. Say we've got this kid who's coming to school late, and they say my son has a sleep disorder, and I want you to do an evaluation. And we say we don't suspect any sleep disorder. We're not doing an evaluation. Parent files a complaint. We turn around and say, we suspect neglect because your kid's walking 30 minutes to school and we suspect neglect. Parents likely to claim that that was retaliation. That's where you get into some of these issues and problems. As I mentioned, one fundamental piece of due process is impartial hearings, where the person who's making the decision is not biased against or necessarily in favor of the kid. We also have impartial hearings where if we take action, the parent has the right to seek an impartial hearing before an impartial hearing officer. We sometimes have hearing officers where it might be an attorney. I've had special education directors from one district serve as an impartial hearing officer for another district, but they have to be impartial and go through that process. So the hearing officer doesn't have to be somebody who is licensed to practice law necessarily, but it's just somebody who understands the process and the procedures. The disability discrimination and harassment, this is again one of those big hot topics that's coming up now. Non-discrimination, as mentioned, you cannot discriminate against students with disabilities. You have to give them an equal opportunity to participate in all of your education, including those extracurricular activities. You can't do things that are less effective for them than for the gen ed students. The whole purpose behind 504 is to provide an equal level playing field for students with disabilities. Non-discrimination can include things where we've got students who are discriminating against other kids. And that comes up like within bullying. When students are bullying their peers on the basis of a disability, a perceived disability, which is regarded as having the disability or record of having that disability, that bullying can be a form of discriminatory harassment that you have to deal with. Same thing as like sexual harassment or racial harassment. That is something that you have to deal with to make sure that the student isn't being discriminated against in the schools. There was a Dear Colleague letter to this effect about 8 years ago that made it clear that that is a form of discriminatory harassment, that it's important for school personnel to be trained so that you understand what your legal obligations are, because if you know or should have known that this was going on, you might be held liable. This is a little bit broader than what the courts typically do. The courts typically require actual knowledge. Office of Civil Rights has this reasonably should have known. You have an obligation to do an investigation, and if you find out that that bullying and harassment is going on, you need to address that harassment, make it stop, and address any of the effects of that harassment. The remaining things, can I just real quick, Mr. James?
Okay.
I was going to talk about
Because I have a parent I have to be
Okay.
at.
Yep, yeah. I'm going to talk about the thing you asked me to talk about.
Okay.
The walkout. We've got a whole bunch of stuff going on right now with student safety. We've got a lot of threats and things, and we know that kids are planning a walkout. There's one talk about a nationwide one being done on April 20th. There are two impacts of this. First on the kids, second on the teachers or others. Kids have First Amendment rights in schools. The Tinker analysis basically says that while kids have First Amendment rights, school districts have the right to censor or punish speech that creates a substantial disruption to the educational environment, typically like a physical disruption. And so it seems pretty clear that if kids walk out of class, they are disrupting class. And in fact, that's the whole intent and purpose behind it. I explained to my son who's a junior in high school, you have the First Amendment right to speak and protest. If you engage in that particular protest, it could be a disruption. The school district will have the right to discipline you. I don't know what the school district would do, but they would have that right to discipline you. It would not violate your First Amendment rights. I, as a parent, would be very proud of you for doing that, however, because the whole purpose of civil disobedience is to create some kind of disruption to get change in our society. So by all means, Aiden, if you want to do that, go ahead and do that. Teachers, one of their big concerns is if kids walk out of class, who's going to supervise the kids, in part for their safety. Teachers cannot walk out of class with the kids without the administrative support and approval, because if teachers do, that's a strike, which is prohibited by PARA, the Public Employment Relations Act, which they are not allowed to do. So unless the administration gives them guidance and says it's okay to go with your kids, they would be engaged in a legal strike. One of the big problems is what happens if some kids don't want to protest and the teacher wants to leave with the other kids. And so you've got some kids left at school, some kids who are going to walk outside around the building or what have you. That's one of the things you're going to have to think about and how you handle. But again, you have the right to discipline the kids. You have the authority to tell the teachers if the kids are engaged in this walkout. We as a district encourage them to engage in their First Amendment rights. We are planning to do this at this time, on this day, in this manner, etc. and allow teachers to go with them. So go ahead now. So you can take that off. And we'll finish up just real quick. Again, the bullying letter from the Office of Civil Rights basically said not only is it discrimination, but it's also very bad if teachers or school people participate in it or see it and take no action. And what's happened in some schools is that this bullying will happen right in front of teachers or other school officials, and they don't do anything. That's when you're going to have liability for discrimination. And it's going to be the potential that there might even be individual liability of the individual who saw it and did nothing.
So this is bullying in general, not necessarily connected with someone that has a disability.
Correct, but if it's with somebody who's connected with a disability, now you've got discrimination under 504. So there's a lot of bullying that goes on. And so if I tease a kid for wearing a goofy looking tie, there's no protected classification. If I tease a kid for being stupid, dumb, idiot, that goes into this idea of a potential perceived disability, regarded as having a disability. That could be a 504 issue, especially if the kid has a disability, whether it's an IEP or a 504 plan, we've got a problem. The letter from the Department of Education also makes it very clear that kids with disabilities have historically been bullied on a disproportionate basis. And so we really want to try to nip that in the bud. And then the last couple of things are some of these Office of Civil Rights cases that we don't really need to get into with that. Just quickly, how to avoid some potential problems under 504. Make sure that your policies and procedures are up to date, that everybody knows who the 504 coordinator is. I had one situation where a school district got a civil rights complaint, and they were asking people in the interviews, who's your 504 coordinator? They didn't have a clue, and nobody in the building knew, and that was a problem. Publish your stuff in your student handbooks and your board policies. Make sure people know this information is available. Train your administrators like we're doing today. Train your staff as well. Train students to let students know that bullying on account of disabilities is a form of illegal discrimination, just as sexual harassment, racial harassment, etc. It's illegal. Whenever you get complaints, make sure you investigate them right away, that you create a good documentation and paper trail of what the outcome of that complaint is, and if you find discrimination, that you address it immediately, take the remedial action to help that kid out. With that, I will give to you, and you don't need to turn it into me, but I will give you a quiz. I'm going to be giving it to the district electronically so that teachers, after they listen to this or watch this, will be able to take that quiz as well. You don't have to turn it into me. I'm just going to give it to you. If you want the answers, shoot me an email. It's true or false. 15 questions, and hopefully you all do well. But this way we can make sure that the teachers who watch this on the recording pay attention to. And thank you all very much for your time.
Thank you. Look forward to